Morning to everybody. Can everybody hear me okay?
Yes.
Okay, Miss Kunkel, are you ready to go? Everybody hear me okay?
Yes, ready to go.
And Miss Boulay?
Ready to go.
Okay. We are on the record in the Colorado Public Utilities Commission's proceeding number 24R-0559EG. My name is Connor Farley. I am the administrative law judge assigned to this proceeding. It is approximately 11:02 a.m. now on August 19th, 2025, and this remote public comment hearing is being webcast. This remote public comment hearing was scheduled initially in a notice of proposed rulemaking that I will refer to as a NOPR, which was scheduled in decision number C24-0940 that issued on December 24th, 2024. And then the initial remote public comment hearing was continued to May 19th. 2025, and that was memorialized in decision number R25-0157-I that it issued on March 5th, 2025, and then it was further continued first at that May 19th, 2025 continued remote public comment hearing, and then in decision number R25-0537-I that issued on July 22nd, 2025. It was at that May 19th continued remote public comment hearing, and then in that last decision that the remote public comment hearing was continued until today. The purpose of this continued remote public comment hearing is to allow members of the public to provide oral public comments regarding the proposed rule changes as proposed first in the NOPR, and then most recently in my most recent decision, R25-0537-I, that issued on July 22nd, 2025. In that latest interim decision, I proposed some further changes to the rules, largely adopting the blue line changes as proposed by Public Service, working with most, if not all of you, to come to consensus on rule changes. I adopted most of those proposed changes as proposed by you all, and then made a few of my own. I also welcomed further written comments regarding the changes, the latest changes, and I got several from you all, which were very helpful. So that's basically where things currently stand. And let me just tell you briefly what my plan is for today, which is I think we have in the record a fairly comprehensive set of written comments and proposed changes to the rules. The last round in particular of me proposing further changes, and then receiving further written comments from you all, really well supplemented the record, and I think we're in pretty good shape. The written comments, all of them, but particularly the latest ones, have been pretty clear. I think I understand them. I will have a couple of clarifying questions for one of you, but I think we have a pretty clear record. So my plan for today is to welcome any further comments that anybody may have. And towards that end, I know that Ms. Concelia and Labor have made available a couple of individuals to provide comment regarding operational issues, and I would welcome any comments there. I don't have any specific questions for Mr. Arnold or Mr. Courtney, but I would welcome any comments clarifying any operational issues that have been addressed in this rulemaking, or that labor feels would be helpful in finalizing these written rules. So I'll take any further comments. As noted, I have a couple of questions, but then my plan is to adjourn the hearing today and then work on the recommended decision together with the finalized rules. And as you all know, you will then have an opportunity to file exceptions with the commission. To the extent you have any issues with the finalized rules that I include with the recommended decisions, so that will not be the end of the road. But essentially, that's my plan for today. So if initially what I'd invite is any feedback from anybody who thinks that's a bad plan or we need more time to get to the right place with respect to these rules. And what I mean by more time is any further opportunities for written comments and or further opportunities at a future date for oral comments. So if anybody feels that way, please speak up now. Mr. Survey of Public Service, please go ahead and welcome.
Thank you. Hello, LJ Farley. For the record, my name is Ryan Survey. I represent Public Service, and my name is spelled RyanServais. So Public Service supports the consensus blue line edits as updated in the modified proposed rules. So we don't see any reason that there would need to be additional rounds of comments or hearing, and would support moving to a recommended decision after this, which is all to say that the plan that you articulated sounds great to us.
Okay, thank you very much, Mr. Survey. I appreciate that. I see that Ms. Concilia popped up first, so welcome, and why don't you go ahead?
Thank you, Your Honor. In reading through the reply comments, or the second set, I realized that perhaps my inartful drafting of some of our comments may have created some consternation, and it is not labor's position to require the application of the Energy Service Public Works statute to items that are done through the ordinary course. And to the extent that I created that confusion, I apologize. And I have with me Mr. Anthony Trujillo from LIUNA, because I represent a consortium and we try and get everyone on our team to agree first before we write comments. And then Mr. Arnold, who was involved in the drafting. He'd been with Pipe Fitters Local, and he has just been elevated to go to the international, although he's going to stay in Denver and work. And who is his replacement is Cecil Courtney, who's also on. And to the extent that you have any questions about what I just said, Mr. Arnold can explain.
Okay. So just one point of clarification. Could you just say your first sentence again? You had said you had not intended with the written comments to create any consternation. And then I didn't follow exactly. Part of it may just be my audio.
It seems that with the other comments that were submitted, that there was a belief that labor was asking for the Energy Section Public Works ESPW statute to apply to projects that were done primarily by gas utility in the ordinary course. And that was not our intent.
Okay, I understand now. Thank you very much for that.
Thank you.
Sorry, I'm just taking some notes. Okay. So, Mr. Arnold, I don't have any specific questions for you. I really appreciate you being here. Um, I mean, if there's anything that you want to add, I'm all ears. If you think the record here would benefit with any clarification, I would welcome your comments.
Well, thank you, Your Honor. I really don't have anything to add, but happy to answer any questions if anything does come up. But I think the record is complete. So I appreciate your help and your thoughtfulness in getting through this proceeding.
Thank you very much, Mr. Arnold. So let me throw the question back out there. I'm not seeing anybody else pop up. I just want to make sure that I'm not trampling over anybody who may think that the plan that I stated and where we are status-wise in this rulemaking, want to give anybody the opportunity to voice a different opinion. So I'll just pause for a moment to see if anybody pops up. And I am not seeing anybody. So I'd indicated I had a couple of what I think will be very quick questions, just clarification points for one of you, and public service and Mr. Survey, you're the lucky participant here. So just a couple of questions regarding comments that you made in your latest initial comments. So the first one has to do, and Mr. Survey, if you are there, if you could turn on your camera, that'd be great. So the first comment I just want to ask a question about is it's on page 5 of your initial comments, and I'll just read you what was written. What I'm focused on is a sentence stating, setting aside the statutory language, the company emphasizes that the commission has the discretion to determine whether a CPCN is required as part of its review processes based on otherwise applicable criteria. And I guess what I'm wondering is just clarification about what those review processes are.
Thank you, Judge Farley. I'm actually going to call in a colleague, if that's okay with you, Pascucci, here at Public Service.
That'd be fine. Welcome, Mr. Pascucci. And did you hear my question?
I did, Your Honor. And good morning. My name's Mike Pascucci, Mikepascucci. And I think the answer to your question is there are a couple of different ways that, from an electric utility perspective, things can be determined in the ordinary course of business. First, the Commission's rules, distribution projects are termed in the ordinary course of business. Second is the Rule 3205 report. Annually, electric utilities have to file a 3205 report that provides forecasts of generation projects to be conducted within the next, I believe it's 3 years by rule. And in there, a utility can ask for a finding that a project is in the ordinary course of business. And then the second annual report, is the Rule 3206 report, which is a transmission-related report. And again, in there, a utility can ask that a transmission project be found in the ordinary course of business. But in both the 3205 and 3206 reports, it's at the Commission's discretion as to whether those are ordinary course of business or require a CPCN.
Okay. Is there any way for the commission, I mean, in the event that public service or any utility does not, a project is not part of an ERP and you don't come in for a CPCN and you go ahead and build the project, Is there any way for the commission after the fact to give feedback along the lines of, hey, particularly on the CPCN front, we think that this was not in the ordinary course of business and would have preferred utility to come in for a CPCN?
Yes, I think so. I think the commission would have, it would depend on where you were seeking cost recovery for the project. But for example, when you came in for cost recovery in a rate case, the commission, as well as other parties, would have the opportunity to review the expenses, review the project, and could, I think, certainly argue that such a project required a CPCN, and the commission would be able to provide guidance or feedback at that time.
Yeah, that makes sense to me. And I suppose the worst form of feedback would be disallowance of cost recovery. But short
Yes.
of that, the commission could allow some or all cost recovery regarding that project, but then say in a hearing or in a written decision, something along the lines of this would have been better sought, better done with an application for a CPCN, something along those lines. That's essentially what you're saying. Is that right?
Yes, I think worst case, if under your example, a utility was to go ahead and um, construct a new substation, for example, or construct a new coal gas plant without seeking a CPCN, the commission could, at the time the utility sought cost recovery for it, either, as you said, disallow the costs associated with that or provide additional guidance as to why that project needed a CPCN.
Okay, I appreciate that. So my second question may lead to a similar answer. Give me just a moment. This is it's on pages 8 through 9 public services initial comments. And it's quite a mouthful, so I'm going to try to look at it and cut it down and see if I provide enough context for either you or Mr. Survey to answer. So give me just a moment. What this is addressing generally is the $500,000 threshold in the relevant statutes that we're trying to implement here. So I'm just going to read the whole thing because I'm not going to be able to cut this down well enough, I don't think. So please bear with me. The quote is that, and I'm going to be jumping around a little bit here, but the company again believes the likelihood for a utility to seek an aggregate cost recovery of less than $500,000 for an ERP or CPCN approved project is low and likely a rare circumstance. Another limited circumstance that could, but again is unlikely to arise, would be the development of joint ventures in which the parties individually seek to recover less than $500,000 each, but in aggregate will seek more than $500,000 in cost recovery. The company does not recommend edits to proposed Rule 3001P to address that circumstance, but notes it only for clarity, given the proposed wording, which states, quote, the utility will request, end quote. Under this unique circumstance, the company believes it would be better for the commission to address the legislative intent of Senate Bill 23-292 on a case-by-case basis. So hopefully you either one of you had that in mind. So the question I have is, what would be the context within which the commission could review that issue on a case-by-case basis? I mean, in other words, what kind of proceeding, if any, or would it be just an informal communication, less formal communication with a utility such as public service? Do both of you understand that question?
I believe I understand the question. I'm just taking a moment because, as you said, that's a lengthy paragraph there. So I was just taking a second to reread the full paragraph.
And please do. So like I said, I think it's in your initial comments at page 8 through 9.
Yes. And what we're effectively trying to say there is, based upon the current market for costs for a project, let's hypothetically say some new generator. Uh, those are going to likely be in the tens, if not hundreds of millions of dollars or more. So for a utility to seek cost recovery of less than $500,000 is highly unlikely given the overall cost or scope of a new generation project in that example. Similarly, a transmission project for the most part is going to be millions of dollars, again, making it a highly unlikely case where a utility is not going to seek more than 500,000. Where you could see that, and it would be a very rare circumstance, I think you would still expect a utility to denote those types of projects in, for example, its 3205 or 3206 report. Say, for example, it's a minor substation upgrade. The utility would likely still, in its 3206 report, note that a small substation upgrade was needed and either request it be in the normal course of business or uh, or the commission would find a CPCN was necessary for that. But those are going to be far and away the exceptions more so than the rules for things already not deemed in the ordinary course of business. Does that
Okay.
help clarify?
I think so. So I think you're on the more formal side. What you're focused on are these Rule 3205 and 3206 reports. Do I have that right?
Yes, and generally what we were trying to think of is you can always think of an exception where something could happen, and there are
Right.
processes to probably catch and evaluate those things. And what we were trying to caution against was making rules for the 1 in a million case that would confuse the other 999,000 cases.
Right. Understood. Um, I completely understand that. And what you say is very persuasive in terms of the unlikelihood of this happening. But, you know, in the law, when you draw lines, uh, um, you know, it can lead to uh, uh, actions to fall on the quote unquote right side of the line, depending on, you know, uh, what your perspective is. So anyway, I mean, that's obviously what I'm concerned about. And so, you know, the less transparency, the more types of gamesmanship can happen. But if the commission has opportunities to effectively look over a utility shoulder and nudge, perhaps push to make the right decisions there, then that's better. And what I think you're telling me is that the commission has those opportunities. You've identified, with respect to this answer, two potential opportunities with these two reports required by rule. Um, uh, so it is what it is, but that's very helpful for me. If you could just tell me, I don't believe I've ever dealt with a Rule 3205 or 3206 report. What happens with those? Do you public service file them annually? And then what happens after that?
So those are filed annually. I believe they're both filed on April 30th of each year. Upon filing that, parties have an opportunity, or stakeholders have an opportunity to comment on those reports. And then commission staff makes a recommendation after reviewing the contents of those reports and the comments makes a recommendation to the commission, whether the utilities request that something be found in the normal course of business be granted or not, and the commission takes those up. Typically, if you file them in April, in my experience, we've often gotten guidance from the commission or decisions from the commission in late Q3 of each year. Now, utilities can supplement those throughout the year, and supplementing those essentially just kicks off the process again. So if we were to file in April, Rule 3206 report that had no projects in it, but in August, we identified a project, we would then refile or supplement the Rule 3206 report. And again, there'd be the comment period and a period then where staff makes the recommendation to the commission as to, for example, it be found in the ordinary course of business or that a CPCN be required.
So, and to the extent there's a dispute between you, public service, and staff over one or more projects in one of these reports, what happens then? Is a proceeding opened up? Is it a litigated proceeding then? Has that ever happened?
In my experience, I don't think it's happened because essentially the commission does make a decision upon the request. So
Okay.
if I filed a transmission project in a Rule 3206 and asked for it to be found in the ordinary course of business, and staff makes a recommendation that it requires a CPCN, the commission would order us to then file a CPCN.
Okay. Understood. Okay. I think I got it. Thank you very much for that, Mr. Pascucci. I see Miss Concelia has popped up. Why don't you go ahead, please?
I just wanted to comment on what Mr. Pascucci said, and this is more based on my experience when I was a commissioner. I don't think I ever saw staff challenge those. I would say that without casting stones on staff, those were usually pretty superficial analyses, and they usually got rubber stamped. So there was not, in my opinion, a robust analysis. So you're correct to be cynical.
Well, thank you, I think. Okay, well, I appreciate that input. So that covers the two questions that I had for public service. I don't have any questions for anybody else, as I noted at the outset. Your written comments have been comprehensive and clear to me anyway, and did not generate any further comments from me or further questions from me. So with that, let me just ask whether anybody has any additional comments that they'd like to make regarding anything relevant to this rulemaking. Okay, I'm not seeing anybody pop up, so let me just say we're at the end of the road now with the public comment hearing. I'm about to adjourn it, but before I do, I just want to thank all of you for your good work on this. I think, frankly, the commission staff did a fantastic job in writing comprehensive and clear proposed rules out of statutes that are not completely clear in my humble opinion. But anyway, I think they did a great job, and I really appreciate all of you getting together, particularly at the beginning of this process, to further modify those rules and come to consensus rules. So Ms. Concelia, I see that you popped up. Why don't you go ahead?
I hate to keep being the fly in the ointment, but labor was not impressed with the work that staff did on these rules. They waited too long. They got them done December 18th of 2024. It should have been done in 2023, in our opinion. And they were, in my opinion, an embarrassment. They just cut and paste the electric into the gas. And so all of us working on this knew the difference, and we had to spend a lot of time. So, we're not going to file triple R on you saying great things about staff, but I don't think the accolades are deserved.
Okay, well, I appreciate that. I will respectfully disagree with you, Ms. Concelia.
Okay.
But I appreciate the input. So what I really also appreciate, like I said, is all of your hard work in generating your written comments here, in working to come to consensus on rules and making changes to the proposed rules that really help to make this process a lot more efficient, and I appreciate it. So with that, let me thank you again. As you know, I'm about to adjourn this public comment hearing. I will then work on my recommended decision with the finalized um, uh, rules. And then you'll all have an opportunity through exceptions, to the extent you don't like anything that I do, to dispute what I've done with the three commissioners. So with that, we are adjourned. Have a great day.